Welcome to our seminar. I'm Alice Reiterfeld. I'm an elder law estate planning attorney, and I practice also elder mediation, probate, guardianship mediation, and I welcome you here tonight. I'm going to talk a little bit about the Medicaid program as it for long-term care issues, not the traditional Medicaid, and get into a few little complicated but interesting tricks that we sometimes use for the benefit of our clients. I'm going to give you general information here, overview information. So I can't really answer people's specific questions on their specific family members, but we can always talk if there's an issue. If you have a question, I'm going to take them during the program because I want this to be interactive, but I also need to get through the material. So if I don't get your question when you post it, make sure we get it at the end. I just want to make sure we get everything. So firstly, we're going to do an overview of the general long-term care Medicaid program. Then we're going to talk about what happens if a person has assets in a trust that somebody left for them and it's going to give them too many assets. We're going to talk about being dual eligible, meaning eligible for Medicaid and Medicare. We're going to talk about making sure the spouse at home makes as much, gets as much money out of this as possible, that less money goes to the nursing home and more gets diverted to the spouse at home. And we're going to talk about one more. Oh, how to get some pending unreimbursed medical expenses paid instead of giving money to the facility, keeping it. So we're going to cover those topics. It's going to be a little bit complicated, but hopefully I'll try to go slowly because I don't speak slowly. And we'll start with just a general overview. So in Florida, all of the Medicaid programs are administered by private companies like an HMO. So if you were in a nursing home and you were getting Medicaid, Medicaid wouldn't be paid by the state. It would be paid by a company that you would register with, and the state pays the company. There are basically two kinds of Medicaid. There's what we call community Medicaid, or managed medical assistance is the technical term. And that's something we think of as just Medicaid in the community for somebody who's poor and doesn't have medical insurance. We're not going to talk about that. We're going to talk about the long-term care program today, because that's the one that's of most interest to my clients. It's very important, first of all, to remember that these companies that administer the program don't have anything to do with whether or not a person is on the program or gets accepted to the program or qualifies for the program. All they are is a payer source. But to determine if somebody's on the program, we follow the Department of Children and Families rules on what's called ICP, Institutional Care Program. And those are the rules we follow, not anything by the private company. So the actual eligibility is determined by the Department of Children and Families. So there's basically the main part of the Medicaid program is the skilled nursing home, or the ICP, Institutional Care Program. And historically, that was all that this program paid for. It didn't pay any home or any assisted living. It was strictly for nursing home. And that's going back really quite a while. Obviously, our lives changed, and our clients' lives changed, and people are living older. So the state realized that some people who are at risk of going into a nursing home but want to stay home should be able to, and it's actually cheaper. It's actually cheaper to keep them in the community. So the state wants to keep people who are at risk of going into a nursing home in the community as long as possible. And that's called the Medicaid diversion program. And that's like a spinoff of the main program. They technically have the same medical criteria, because if you're at risk of going into a nursing home, you have of the level of care of somebody in a nursing home. And they absolutely have the same financial requirements, but they are administered quite differently. And so let me go over that a little bit. First of all, the ICP nursing home program is an entitlement program, meaning that you are going to get this program if you qualify. Even if every single person in the state of Florida applied at the same time, the state would have to provide these services to you because it's an entitlement program, as long as you meet the criteria. The spin-off, the diversion program, has a waiting list. But because again, it's designed to keep people at home, the waiting list is not by how long you've been on the list. It's based on how much care you need. So the goal is when we, help our clients along, we want to make sure that their medical portion of the application is done perfectly and done right. They do it on for the diversion program, they do it on what's called a grading system, and you get a certain number of points for needing a walker and a certain number of points for having dementia. It's kind of a strange system, but we help our families because families have a tendency to forget, not to excuse the pun, but families have a tendency to forget that their family member may have issues and illnesses that they're not even thinking of, and we want to make sure that everything is reported. What we do as elder law attorneys is we help families qualify for this program legally and honestly using the Department of Children's Families rules. This is legal advice and it's legal work, so it should be done only by a lawyer, and the Florida Bar has basically said so. We also advocate to have our clients moved up on the list if we think that they are medically allowed to be on the program. There are some asset and income limitations. The income is never really a problem. If we are over income, we can do a trust, so that's not a problem. The assets are usually the issue that we're dealing with. The person in the facility is allowed to have $2,000, and the person in the community, the person in the facility is allowed $2,000. If they have a spouse in the community, the spouse is allowed to keep $126,000 because we don't want to impoverish those spouses. Okay, so as we said, the diversion program is a spin-off from the nursing home or ICP program. Because you can't go through the program unless you medically qualify in the diversion program, the medical stuff comes first. And then if you're called off the list, we do the financial. It's the opposite for the nursing home program. First, we do the financials because if you don't qualify financially, there's no point in assessing you. But again, it's the same qualifications, certainly financially, for both programs, identical. Interesting to just remember, if a person is already in a skilled nursing facility, it is sometimes easier to transfer from the skilled nursing facility to this community or an assisted living facility and not have to go and be put back on the list. So it's important to keep that in mind because that's a real tool that we can sometimes use. The only other difference is that in the ICP nursing home program, the Department of Children and Families is going to make you pay money, and usually it's your income, to the facility as your patient responsibility. Sometimes it's called a copay. You would think of it as a copay or a share of cost, but in this arena, it's called the patient responsibility. And it's typically the person's income less a needs allowance of $130. We're going to get into the patient responsibility a little bit more later, but obviously there would be no patient responsibility with the diversion program since there's no facility to pay the money to. Okay, so this is something that comes up more than you would think. Our client will come to me and or a family will come to me and mom needs to apply for Medicaid. Dad has long passed away, but there's an old trust that dad left for mom in 2001. And the reason this money is in trust is because at the time, mom and dad were trying to reduce the estate taxes that they would have to pay because at that time, you could shelter only $675,000. So if you had a little wealth, you would want to take advantage of 675 times 2 people, and you would do 2 trusts. The problem is the money sitting in those trusts is available now to the person who may want to qualify for Medicaid. Sometimes it's a newer trust, and it was just done by an estate planning attorney who's not really thinking of long-term care issues and just does a trust and provides for a spouse, and then, oops, the spouse becomes incapacitated and it's not working for this family anymore. Typically, estate planning attorneys are more concerned with death and taxes, but the tax rate now is 11 million. So I don't have too many clients who have more than $11 million. So we don't worry about taxes too much in this office. Big jump in 20 years. So since we're focused on lifetime issues, that doesn't happen to us. So what do we do if we have this old trust? Well, we can go to court and we can ask the court to fix the trust, or what's called modification. And it's really quite straightforward, because you're going to say that, look, the person who set up this trust certainly didn't mean to set it up and take away any public benefits they were going to get. They weren't even thinking about that 20 years ago. It's in the best interest of the person that's going in the facility to reform this trust. The spouse who's passed away certainly wants the living spouse to have a high level of care, a high lifestyle of living as possible. And the court will take the trust and will create a special needs trust for the person going in the nursing home, because that trust will not count as an asset for the person going in the facility. So we've gone to court probably a dozen times in the last 5-7 years to fix these trusts, because you can't just take the money out. Medicaid's going to see that. They're going to see you have available assets. So you have to modify the trust. And sometimes we do it right before we're applying, but I've had guardians come to me to do it for them, pre-planning. They know this person's going to need benefits down the road, so they want or may need them. So let's get that trust taken care of before it becomes a problem, and we have to do it quickly because the courts are not quick. Okay, let me see how we are on time. Okay, we're good. So another thing that comes up is we have a person in the nursing home, and I'm just going to call it the husband, because husbands typically have more money than the wives in terms of their income. They're more likely to have a pension or higher Social Security. So I'm just going to call it the man, but of course it can be the other way around. So let's say we have a man that's going into a skilled nursing facility, and he's got $4,000 a month. He's got $4,000 a month of income. He has Social Security and a pension. If he were single, most of that $4,000 would go as his patient responsibility, that copay, towards the nursing home, and the state pays the balance, and that's between the state and the nursing home. With a spouse in the community, however, they will divert some of his money to that spouse to bump her up to $2,200 a month. So if she has $1,000 a month in Social Security, they're going to give her $1,200 to bump her to the $2,200. Well, that still leaves $2,800 that's going to the nursing home. And the care that the husband's going to get has nothing to do with what his patient responsibility is, whether it's $1 or $10,000. He's on the Medicaid program and he's going to get the same care. So why you don't want to leave that $2,800 on the table? So again, we're going to go to court and ask the court. And usually you can do this in a guardianship proceeding, or you can do it in the family court, and ask the court to increase the wife's amount of money that she gets, because she needs to live on that, and because it's not going to affect him one iota. And we've done that. And now, obviously, that costs money in attorney's fees and court costs. But for this woman in this example, which is fairly typical, $2,800 in a few months, she's even. And then after that, she's way ahead of the game. So we don't stop at just what the state lets us have. We can go further, and we can ask the court to give us more money. And so just, okay, so do you have any questions yet in the chat? I have one. Let me see what we got here. So somebody's asking me if we reform to a SNP or to a no, we've reformed to a special needs trust. Anything else that we do with the money is going to be considered available to the person in the nursing home, and they're going to be ineligible. We have to ask the court to put it in a special needs trust, which is not going to be considered available to the person in the facility. So we're going to amend the trust. Excuse me a second. So we're going to amend the trust as if it was done initially as a special needs trust. Let me just look at the rest of the question because it's a technical question. The next question is, have I found that the court will limit? No, I found that the court, as long as the court realizes that nothing's going to change for the husband, we usually have to have the husband represented, that the husband's going to get the same benefits and she's going to get another $2,800. It's no skin off their nose. They're happy to do it. Now, I usually have to file a financial affidavit in family court, so I almost always do one where, you know, unless it's just completely bogus, $5,000 a month isn't really hard to spend these days. So we can justify that, but the courts are really pretty good about it because there's no harm to anybody. Okay, so the third thing I wanted to talk about was what's called unreimbursed medical expense deductions. And this is kind of a trick that we've been using all along, but we've really been using it recently and lately. And the reason for that is you can ask the Department of Children and Families to deduct from your patient responsibility, the money you're getting them every month, certain things. So we already talked about that they will give the wife or the spouse at home some money. We also talked about the $130 personal needs allowance, but they will also give money to pay for insurance premiums or co-pays or things like that. They will pay for any outstanding medical expenses that are not being paid for by some other source, either Medicaid or Medicare. So let's say today is the last day of January and somebody comes to me tomorrow and they want to get January benefits. And we just can't get it. Their income is over. We have to do something with money, whatever. And they have to pay privately for the month of January. In February, when we get the benefits, I can ask the Department of Children and Families to deduct from the patient responsibility any outstanding medical expenses, including that nursing home bill. So if, for example, somebody has a $2,000 a month and that would go to the nursing home as their copay, and they owe this facility $5,000, I can ask that they have no patient responsibility for the first 2 months and half of the second month to pay what they would have had to pay in the facility anyway. It's kind of bizarre, but it's sometimes even a planning tool because depending on what the person's income is, depends on whether we even want the benefits in January or we want them in February. So if the person has other outstanding expenses, they may have long-term care expenses or whatever, all of that can get deducted from patient responsibility down to zero. There's still going to be a patient responsibility determined, but you won't necessarily owe anything. So anything medical gets deducted, money for the spouse, or if there's other family members that are being taken care of for them, that personal needs allowance, and the maintenance allowance for the person in the facility. So I gave you the examples. You file late. The other reason that sometimes this comes up is if we have too much income, we have to prepare a trust. And if someone comes to me tomorrow, they may not have an opportunity to get that trust done in January because it's the end of the month. I mean, we can prepare it, but they have to go to the bank. It's so hard now with COVID. So if they don't get it funded in the month of January, they won't be eligible for January. But we have this backup of getting those unreimbursed medical expenses deducted from our patient responsibility. So that's kind of cool. Let me see where we are. Okay, we're good. So the last topic I wanted to discuss with you is being duly eligible for Medicare and Medicaid, which means that you would be able to get both benefits in the skilled nursing facility at the same time, but it can be a little tricky. Medicare is the health insurance that is for seniors over the age of 65 or disabled. It's part of what gets taken out for your Social Security. It's not an entitlement program. Anybody will get Medicare no matter how much money they have when they reach that certain age or they become disabled. Medicaid is a poverty program. So think of aid to distinguish between Medicaid and Medicare, because everybody gets them confused. And of course, when these two things were passed in 1964, it made a whole lot of sense to name two completely different programs with names that are so similar. But be that as it may, they did. So we're talking here today about Medicaid, but now we're going to talk about using both of them to help us pay for long-term care. So a very typical situation that comes into my office is somebody calls me, mom fell, she's in the hospital, she needs hip surgery, and then she's there for a few days and she's going to be transferred to a rehab facility, which is a skilled nursing facility. That's the typical thing. If you're in the hospital for 3 days, 72 hours, and you are admitted to the hospital, then you can transfer to a rehab facility and Medicare will pay a portion. Now, you have to be admitted and you have to make sure you're admitted, because they can keep you on observation for like an hour, like 10 years if they want to. So you have to make sure you're actually admitted, because some of these facilities really screw around with that, although less than I used to see. So admitted in their 72 hours, and now we're going to move the person to a skilled nursing facility. And Medicare is going to pay up the first 20 days in full, as long as the person is getting a benefit from the benefit, and then up to next 80 days, they will pay less the patient, your portion, your copay, which is, what is it now, $185 a day. So sometimes you get cut off a lot earlier because the rehabilitation isn't helping or doing anything, so Medicare is not going to keep paying, and then you have to, at that point, switch to Medicaid. But you also may need the Medicaid when you're also getting Medicare. And you have to coordinate this really well, and you have to make sure whoever's working with you coordinates this really well. So we don't want that client to be hit with the $185 a day. If we apply for Medicaid, Medicaid will pick up that $185 a day. So you will often hear people say, well, I don't need to apply till the person's is not on Medicare anymore. No, you need to get the full benefits, or that copay isn't going to be paid for. Now, you can try to get the UMEDs like we talked about before, but that's a silly way to do it. So you have to coordinate with the facility to find out how long they think Medicare is going to go and when they think you need to apply, and whether the 185 is being picked up by another source. Sometimes a person may have long-term care insurance or a Medigap policy that will pay the difference. So we don't need to apply for Medicaid until all of that stuff runs out. But if they don't have those other sources, then we have to apply for Medicaid while we have Medicare. So we don't have to pay that $185 a day while they both are covering me. And then at the 100th day, it's straight Medicaid. And since we are already in the skilled nursing facility, typically we stay and just switch the way the person's paying to Medicaid. So that's very common. Let me just make sure I didn't miss something. So just want you to remember, in order to get that co-insurance, that Medicare $185 a day paid, the person has to be on complete Medicaid ICP, not some other program, not partially, but have all the benefits that they would get if they didn't have Medicare at all. Okay, let's see where we are. Okay, good. So I hope you learned some of these tips today, and that will make you better educated and understand. Whoops, what's that? Should I just shut it off? Sorry. Okay, something popped up on my screen. So I hope you're better educated, and I want you to understand that Medicaid can be, not always, but can be a complicated process. It's not a fill in the forms kind of thing. Otherwise, it wouldn't be a substantial portion of the board certified exam for elder law on how to get Medicaid benefits for clients. So it can be very complicated. It does have a lot of twists and turns in it. A lot of the things must be done by attorneys, any contracts, any trusts, things like durable powers of attorney, any of those things. Now, some people will say my application is very simple. The only application that truly is simple is where the person is under the assets, they have no money, and their income is under the cap of about 2,200. That person may not need anybody's help, and we will tell them that. We will give them exactly where they need to go and what programs they need to get online to do it themselves. But that's more rare than it is common. And most of the people who come in to see us because there is something that needs to be done to preserve their assets. And sometimes people will say to me, well, I only have $80,000, so I don't need to do this. But actually, it's the other way around. Because if I have $80 million, I got plenty of money. But if I have $80,000, I may need that to last me for the rest of my life. And even if I'm on Medicaid, not everything's going to be covered. Not my clothes, not my television, not my personal things, not dental, not a whole lot of things. So maybe dental, but the point is that we want to protect that money for the person in the facility to keep, in case they need an aid, to keep their standard of living as good as possible, because rich people don't need to do this. So again, if there's anything but the most simple application, you should bring in an attorney, and so we want to make the family as whole as possible. We want to get you everything that you're entitled to. And we want to make sure that when you leave our office, nothing comes down the line that we didn't anticipate. So we anticipate what's going to happen if we want to sell the house, or all of these things that may come down the line, which isn't going to happen when somebody just does an application. So I want to thank you for your time tonight. And if there's any questions, I will be happy to answer them. Let's see. Nobody else. Okay, well, I'll give it another second and then, whoa. Oh, who's that? I don't know what happened. Okay. All right, well, since we don't have any questions, feel free to contact our office if you need any help on anything to do with Medicaid or anything else in elder law or estate planning. And we're going to continue to have these webinars, and we will keep you posted. We usually have them twice a month. So I'll look forward to seeing you at the next one, and thank you for attending this one. Good night.